I would not invest in Kenya. This country has a strong judiciary. This country has the rule of law. My matter is in court. I am sure it will be adjudicated fairly. That gentleman, Your Excellency, is Steve Jennings, and his little investment is Tatu City. He did not want to know anyone, but he knew because we have a strong and firm judiciary, we have the rule of law, we have a court that can stop a presidential inauguration, and also a court that can quickly, swiftly, following the due course, swear in a deputy president. After other institutions have finished their work, Kenya is a destination for investment. He told me, Your Excellency, he told me that even if he was given free land in some of the neighboring countries because of diplomacy I shall not mention, even if he got free land, he would not move there. Because a change of regime would mean risk to his investment. I really want us to appreciate the judiciary of the Republic of Kenya. Because, Your Excellency, without them, this would not be a destination for investment. We congratulate you for the number of years that you've had. We have had ups and downs in this country, but everyone has always known that there will be objectivity in your findings. But your objectivity also must not mean popularity. It must mean just doing the right thing. I was thinking this morning when I came, what does it feel like to be a judge of the Supreme Court? I don't know, Emeritus Mutunga, how does it feel like? Chief Justice Maraga, it's almost a godlike, the finality of your decision. You know, I would draw you to one of the points by Khalil Gibran on punishment and crime. And he speaks to it, that must be exercised in a way that is judicious. Because ultimately, the ultimate judge is God. I really admire the judges of the Supreme Court that we have. You exemplify, that attribute that this country must be. And even us in other arms of government, we look up to you. On behalf of governors, I thank you because you have stood for devolution. You have supported devolution in this country. I remember as a senator marching to court, we frog marched our speaker. He didn't want to go. He's now a governor, Lusaka, he's governor again. We told him, you must go. Because at that point, we felt devolution was under threat. The deputy president was also there, marching to the court, Professor Kindiki. But we found solace. And many times, the judgments will not be popular to us or acceptable, but they must be respected. And so I am happy that we have judges who are immune to popularity. You don't have to make a decision whether that is popular. Leave popularity to President William Ruto, Professor Kindiki, PCS, and ourselves. We are the ones who want to be popular with the people. But for you, just do what is right, as sober as a judge, and our country will remain solid. Your Excellency, with those many remarks, I know we've had a discussion about our favorite topic, which is the land over here, the Nairobi County land, that will soon host the Supreme Court building. I had mentioned that I have never been a client of the Supreme Court. I don't intend to be in my individual capacity soon, unless I vie for presidency one day, you never know. But in my individual capacity, no. And so I would not want to be out of favor with the Supreme Court. The land over here, you have pronounced yourselves, and the Constitution, Article 62 says all unalienated public land, as at the point of promulgation of the Constitution of Kenya, is vested with the NLC and with the county government. For us to do that proper allotment, following the procedures, to have a new Supreme Court building would be something that we'll all be proud of as a legacy of President William Ruto, myself, and the Chief Justice. So please count on our support. And also, Madam Chief Justice, you're the chair of our Nyumba Kumi over here, being the first resident. Please convene us once in a while. Convene your neighbors at City Hall, at Parliament, and at the Executive, even for a cup of tea. We'll be very happy to come. With those many remarks, Karibuni in Nairobi. I've been asked to welcome you to Nairobi, though I know all of you live in Nairobi. But I'm sure it feels nice to be welcomed by the governor of Nairobi every so often to your home. Asanteni sana, and may God bless you.
Thank you very much, Governor Sakaja. It is now my pleasure to call on the Supreme Court Judge of Kenya, Judge, Honorable Lady Justice Njoki Ndung'u, to make some remarks. Tumpigie makofi akija tafadhali. Welcome.
His Excellency William Samoei Ruto, President of the Republic of Kenya, the Deputy President, Honorable Professor Kithure Kindiki, the Honorable Chief Justice of the Republic of Kenya, Lady Justice Martha Koome, Honorable Chief Justices of various jurisdictions, Deputy Chief Justice Lady Justice Philomena Mwilu, Prime Cabinet Secretary Musalia Mudavadi, the Governor of Nairobi County, brothers and sisters, judges, distinguished guests, ladies and gentlemen. It is my honor and privilege to welcome you all to the Supreme Court at 12 Jurisprudential Conference. In early March this year, the judges of the Supreme Court of Kenya, during our annual retreat, realized that the time has come for us to engage the Kenyan public, including ordinary Kenyans, civil society groups, members of the bench, members of the bar, and academia, as well as state actors who are affected by our decisions in their work and in their lives. We also determined that we would engage our colleagues in other apex courts, both in the African region and globally, to assess our progress as a court and to ensure we remain on course as guardians of the Constitution. It has always been the rule of thumb, however, globally, that judges speak only through their judgments. However, in the contemporary world, judges often find themselves under intense scrutiny and criticism without a chance to respond or engage, even to clarify, if need be, the reasoning of their decisions. Traditionally, judges have had no platform from which to speak apart from the courtroom, from where, in an adversarial system of justice, at least one party leaves unhappy. This conference is therefore conceived by the desire to demystify the court's role and processes and to correct misconceptions about its mandate by deepening public understanding of the court. While judges are not infallible, in a democratic space, the public need to be afforded structured engagement where, from time to time, they can learn about what judges do, where they sit, when and how they do their work, and most importantly, why they do it. This is the reason we are all here today and this week to share, to engage, to learn, and to reflect. Your Excellency, allow me briefly to reminisce on the history of our Constitution and in particular the evolution of the independence of the judiciary. Kenya's constitutional journey to date has been a fairly long and tedious process, from the Independence Constitution and to numerous amendments to it in 1964, and many from 1969 to 1991, and later in 1997. Many of those early amendments, particularly those before 1991, changed the character and tenor of the Constitution. Judiciary estimates were considered not independently, but we were considered a department, like the Office of the Attorney General. The security of tenure of judges was removed, drastically and adversely affecting judicial outcomes, with judges being appointed and dismissed at will by the president, and calls would come in at night from political actors directing what judges should do the next day. These were dark times indeed. Thankfully, this is no longer the case. By 1990, Kenyans were demanding for change, including opening up of democratic space, respect for human rights, accountable state institutions, and independence of judges. Comprehensive constitutional review, however, only began in 2000 with the appointment of the Commission, the Constitution of Kenya Review Commission, of which my brother Isaac Lenaola was a commissioner. That commission worked on a draft bill that was subject matter to the Constitutional Conference at Bomas of Kenya. Your Excellency, you will recall that in 2003, you were a member of the Parliamentary Select Committee on the Constitution. I believe that is where you and I first made acquaintance. And as members of Parliament, we were both delegates at the Bomas Conference, which adopted the CKRC draft bill in 2004. It is the CKRC draft that first made provision for Supreme Court. Similar provisions were contained in the document that went to referendum in 2005, but failed to meet the required threshold and was rejected. Kenya then went into the 2007 election without a popularly adopted constitutional framework, and as a result, in part, the election of 2007 precipitated a political crisis as never been seen before. As part of the resolution of the peace process that followed, the Committee of Experts on Constitutional Review, of which I was a member, was appointed to harmonize all the previous bills and drafts and to seek the views of Kenyans on contentious issues. And as a result, the Constitution of Kenya 2010 was adopted by Kenyans through referendum. This Supreme